Buju Ndinwe Maganidok, Ni Jinishnabek, Ni Chmazik, Giganos Ndijnikas, Nea Shi Nigiming and Donjaba, Nigigindodem. I'm John Boros from the University of Victoria, Faculty of Law. I'm the Canada Research Chair in Indigenous Law.
What does Indigenous law mean to you?
Indigenous law is a way of organizing life, and in Anishinaabemowin, which is the Indigenous language that I can speak from the Great Lakes area, we organize life in accordance with principles of Minno B'Madazuin, which means to try to live well in the world. And law is a structure of behavior, a pattern of living that tries to inculcate ways of good living. And there's lots we can get into about that basic concept, but for me, that's what law is. So, law isn't just an idea, it's a practice. And there are many different First Nations across this country, Inuit, Métis people, and they all have their own ways of organizing life. And they can be different as other nations on the earth. And so what you need to do is understand what their ways of living are that try to aspire to that goal. I say try to aspire to that goal because we often, as humans, are weak and we fall off of that path. And that's why we need law, is because we have so many difficulties and so many challenges. Sometimes there's a misconception that law flows from everything that's good and beautiful and wonderful in the world, and that can be true. But law also flows from conflict. It flows from great indecency, where we need ways to be able to at least manage for the moment those challenges so that we can try to put our lives together in more productive ways. Yeah, so we try to pay attention to the peoples that live here and have lived here for thousands of years because they have wisdom and knowledge about this landscape, this ecosystem, and from their language, from their practices, from their ways of being in the world, you can learn about the patterns of how to live well here in these forests, with these animals, with this ocean surrounding us. And so the laws really do flow from the people, and they also flow from the ecology. And it's so important to listen to the sound of the birds and watch the deer as they walk by and pay attention to the changing weather patterns and try to take some clues as you talk with people from those very patterns that you see in the natural world around us.
Can you speak to ways of teaching Indigenous law?
Well, I think first of all, there needs to be an understanding that the classroom is only an introductory doorway. And when they walk through that doorway, they're going to be walking into communities and walking into different territories. And so my goal is to help students feel an interest in walking through that door and getting involved with people, getting involved on the land in the territories. And so what I try to do is tell them some of the stories of the places that Indigenous peoples are from. I try to help them understand who the people might be that they could interact with. And then I help them try to understand how Indigenous law would interact with Canadian law so that they see it as a part of Canadian law as well. I think sometimes students might have this misconception that Indigenous law is just separated from who we are living in this country. But Indigenous law surrounds us not only as Indigenous peoples but as Canadians as well. And so sometimes I think when the students see that Canadian law includes Indigenous law, they see the relevance of that to their lives and to their practices. And so it's not, again, just an academic idea, but they can see the practicalities that would be a part of their career and a part of living well as lawyers, as attorneys, future judges in their lives.
Can you speak to how Canadian law and Indigenous law are connected?
Indigenous peoples were the first law keepers and law givers in this land. And when others came to live amongst them, particularly east of the Rockies, they often participated with Indigenous peoples in rich ceremonial councils where the settlers agreed to be able to follow and share some of the laws that Indigenous peoples had. And so you get this world through treaties that creates what's often called in courts intersocietal law. The law blending Indigenous societies' laws and the common law. And so what I'm helping students to try to see is our court says a morally and politically defensible conception of Aboriginal rights incorporates both legal perspectives. Right? Our Constitution as Canadians incorporates obviously what is here first through Indigenous peoples' laws, and that intermingles and incorporates the common law principles as well. So we have a framework of law that helps us understand how we all are built upon Indigenous laws in this place.
How are inclusion and engagement part of law?
So law is worked out in community. It is a practice, which means that it has to be accessible to all people. And one of the things about Indigenous law that I really enjoy is that it's put together in ways that not only lawyers can understand, but community people who are familiar with the stories or know about patterns of living or are trying to live in accordance with their laws of Minopamatazuin, whatever they might be from their nation. And that's a very democratic thing. It's very participatory. And I think it actually has an advantage sometimes over the common law and over the civil law. There, of course, is great democratic aspects to the passing of laws in Parliament and the hearing of cases and deciding cases, but they often tend to be removed from daily life. They happen over there in that courtroom or over there in that legislative building. But for Indigenous peoples, they happen through our interactions as we try to internalize and persuade one another as to how we might live. So you don't need to be an expert to be able to practice Indigenous law. You are made aware of the explicit nature of what you're involved with, and once you're aware, you have some ability to direct it. You have some agency in relationship to it, and that can help with community planning and education. It can help in dealing with local issues around allocation of resources. So there's really an impulse to look to widespread engagement in the living of Indigenous law.
How are gender and Indigenous law related?
It's really important to deal with gender when you're talking about Indigenous law because there are many stereotypes and generalizations that are present in the land, both within Indigenous populations and beyond. And those stereotypes and generalizations can be very damaging because what they do is they limit the way people can function within the legal system by assigning them roles that might not necessarily be what their gifts are and what their talents are. It also can be damaging because it can diminish people. Historically, women have been greatly diminished by understandings and stereotypes that assign men all the important roles in the development of Indigenous law. And as we've been talking about, Indigenous law is practice-based. And if it's lived, you can't only just have half of the population men living it and half of the population men proclaiming it. It has to be something that people are engaged with in a holistic fashion. And so it's really important to be open to and facilitate ways to develop critique of generalizations and stereotypes that build upon views of women and men that don't open up the wide array of possibilities that are open to men and women in the way that they can interact with one another, make law, deal with one another. Well, one of the things I think is we've sometimes had a romantic view in our communities as Indigenous peoples that the past was a time of harmony between men and women, and before Europeans came along we all lived in balance with one another, and that's just not the case. And one of the pieces of evidence that you can take from that is we have many stories that talk about abuse and violence and murder and women not being given place in the political system. And these stories help us understand what our responsibilities are because they're directed towards a critique of the way that women have been treated in the past. And if they haven't been, we can develop that critique today. So there's stories about women being married to other people without their agency being involved. There's stories about women being isolated or physically harmed through violence. And we can see those stories as a resource as to what we might do today, either to analogize if there's a way that they dealt with that violence in a positive way. If they didn't, we can distinguish, saying we're not going to do that today. Just because our ancestors lived like that once upon a time in that way, we don't have to pick up that pattern of behavior today. So those stories function that way, and they just also show us that there was never a time when we didn't need law, because it's always been the case that we've struggled as human beings, including in our relationships related to gender.
How can we take on tough questions in our communities, with elders, for example?
So often I think what helps when an elder might be speaking in ways that diminish women is to look at different angles of vision on that experience. There's never just one elder. There's often many different elders, and so through cross-referencing and triangulation and having different voices involved, it's possible that you could change what the understanding of the circumstance might be. We also have to be aware that not only do we respect our elders, but we also respect our children and we respect our youth. And it's important that they are there and part of that conversation, and they often bring those concerns, and they sometimes will gently and sometimes not so gently challenge what an elder might be saying that isn't a step with what we're thinking today around gender. And so the point is, when it's done in community, when it's done in context, it doesn't have to be demeaning of that elder. It can just put other options on the table that show that perhaps that view isn't the view that's being carried by the majority. And if the majority is carrying that view, that's another challenge, which then takes us into the wider legal tradition, because it's not just one community that carries that law. There's other associated communities that are from the same linguistic tradition, same cultural tradition, that you could also have a conversation with. And of course, our laws as Indigenous peoples should be in conversation with all other laws in the world. We want to bring in the best of what's present in the common law and the civil law and in international law, and we want to reject what's not good in those systems. So we should see ourselves being in that broader conversation, which would then also raise issues around gender as well.
Can you talk about what you have identified as the 5 sources of law?
So there are many ways that you can learn about the law, and I tentatively identified 5 sources. These aren't silos, they're interrelated with one another, but they're a way to start thinking about what our obligations might be, how we might live together with one another. So one of those sources of law is sacred. These often flow from the teachings that are given from the time of memory as Indigenous peoples. How we got here, what our creation stories are, what our trickster figures are, how we understand our origins in this place. And within those stories are principles, standards for judgment, criteria to be able to measure how we should live today. Sometimes those stories are a little bit more secular. So for instance, when I was working with the elders in Saskatchewan, they saw their treaties as being sacred creation stories because they helped to create Canada in that part of the prairies. Canada wouldn't exist in the prairies if the elders hadn't invited the settlers into a relationship of peace and friendship and respect. So the sacred story is a story that we give deference to, we give awe to, we give respect to, we set it apart because of the reverence that we might owe to it. Another source of law has to do with the environment around us. So you can hear these ravens and these crows talking to us. And what you try to do is you listen to their voices, and you can remember stories about the raven and when the raven came into the world and how he released the people or tricked the people. And in those stories again are principles about how we might direct our own behaviors. So we listen and we hear from the ravens, or we might see a deer and remember a story about the deer, and we apply that in our lives. In other words, law is an analogical process. We reason by way of analogy, and the common law often reasons by way of analogy by looking to past cases that the courts have decided. Well, Indigenous peoples reason by way of analogy by looking to past events that have taken place on the land. And so when you see a tree, when you hear a bird, when you listen to the sound of the wind or the waves, you remember, oh, there's a law about that. There's some standard for judgment that's there in that very behavior that you see in the world. These sources of law, sacred and environmental, often require a third source of law, which is deliberative. We need to talk with one another about what it means when that crow calls, or what how we might interpret that trickster story or that creation story. And as we deliberate with one another, as we talk with one another, it's obvious that persuasion is needed at that point. Because you can't just do what you want. You have to do this as a group, as a community, as a collective of people. And part of that persuasion is understanding that it's not just what once was important to Indigenous peoples in their laws, it's what's important to us today. So for instance, concerns about gender have been sometimes neglected within Indigenous communities. And in order to be persuasive with our deliberations, we need to ensure that gender is taken account of in a way that doesn't stereotype, generalize, create vulnerabilities or power imbalances. So persuasion is always a present-oriented activity, which means that our traditions are living traditions. Right? They're not just about what once was, once upon a time, essential to us. It's what's essential to us today. Another source of our law comes through things that are proclamations or declarations or chronicles or codes. These are often one-liners. Don't do this in this place. When you go out, do that. When you go out and take a deer in our community, make sure you leave tobacco, leave gifts in return. These chronicles, codes, regulations, rules are given to be able to guide us in particular moments. They might have been a product of deliberation at once upon a time that arrived with that saying. They might have been a product of looking at the environment or listening to one of those origin stories. But these positivistic laws, as they're often called in Canadian legal context, function somewhat analogously to what legislation does, regulations does. They may be the sources of law that most Canadians think about when they think about law. What's on the books? Well, in this case, it's not necessarily what's on the books, although it could be, because First Nations draft legislation, draft regulations. But it's what are the standards of conduct that people will tell you that you need to be involved with. And then another source of law, the fifth source of law, is custom. And these sources of law are established patterns of behavior that have been developed over the years that help to create life in an orderly fashion. So I don't know if you notice when you walk down the street, people generally try to pass on one side and not the other side. No one tells you what side to pass on. Sometimes we get confused about that. But there's just ways of interacting that we don't think about, that's second nature because of how we've implicitly seen through deduction what the best way to be able to behave in the world is. And so Indigenous peoples have customs that they've developed through the centuries that when you live in accordance with them, people recognize that. And they give you all sorts of goodies. They give you honor and they give you praise. You might be able to participate more in the economic development of the community. You might find yourself more in a political role. So custom encourages good behavior. If you don't live in accordance with custom, what you often find is you're cut out, right? There's disincentives. People will shun you or not necessarily approach you with the things that are needed in the community because they know perhaps that you're not necessarily living in accordance with the patterns of behavior. I should say there's a wide variety in those patterns of behavior. It's not like everyone is walking in lockstep, but there's kind of a range of the way that people might behave. So those are sacred laws, environmental laws, laws that are formed through deliberation, laws that are created by positivistic declarations, and then laws that flow in accordance with custom.